All right, my friends, I just pressed the Let's Go Live button over here on our end, and that means we've got to wait for the stream to fire up all across the fruited plain of the interwebs before we go ahead and get started. Got to make sure those tubes connect on the YouTubes, the Rumbles, the Locals, the Telegrams. It looks like they are connecting. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about the cover-ups that are failing and the reversal of the fake insurrection lawfare attack plot brought by Liz Cheney and the Democrats, because Congress is now working to fight to reverse the subpoenas and the ones that came from the illegally constituted J6 committee led by Liz Cheney and Benny Thompson and Cryan Kinzinger and the rest of them. And so this is interesting because there's a big question, right? Steve Bannon has to report over to prison here very soon in just a few short days. And there's an attempt here to see if there's something that they can do to reverse these subpoenas that came out from Liz Cheney and the rest of them. Someone behind this is called Eric Burlison. He is a representative over from Missouri, and he introduced this legislation that we'll read through today. It's actually a resolution introduced in the House meant to just unwind a lot of what Liz Cheney did. And remember, they passed their own resolution, H.R. 503, and H.R. 503 is what said that there should be 13 members on the J6 committee, 8 Democrat, 5 Republicans, and those individuals should have been nominated by the minority party, which would have been the Republicans at the time. So 5 Republicans. We didn't get that. We got a total of 9 representatives, 7 Democrats, 2 Republicans, Cheney and Kinzinger. So it is a question, can the House pass this and undo that, or does it end with that prior Congress, right? If the prior Congress thought you were in contempt, does that terminate it? Or is the subpoena still open and valid? And so, in other words, would this make the Steve Bannon case moot? We'll go into this and see. We'll see what the bill says, see if it gives us some guidance on it. Marjorie Taylor Greene is supporting this. And we've got some reaction from many people on the left. They are very excited that Bannon is going into custody. Couldn't be more thrilled. And they're also excited he's going to what seems like a problematic jail cell. And this is curious. These people are supposedly very empathetic, very kind, very caring to their fellow men and women. Unless it's a MAGA person, then they just want them dead. And we have a question. We know what happened to Epstein when they put him in prison and kept a close eye on him. So is that something that they want to happen with Steve Bannon? I hate to even put it out there, but it's true. It's why are they so giddy about jailing Trump deputies? Why? Dan Goldman says that he is, in my opinion, he's doing what they call stochastic terrorism, right? Remember they say that if you even criticize anybody, it basically means that you want them dead or something like that. Well, Dan Goldman is criticizing Bannon, and if they lock Bannon up, and we have a representative of Congress who's now castigating Steve Bannon on national TV repeatedly saying he's an insurrectionist, he's a terrorist, he almost ended American democracy. It's almost like he's stochastically encouraging something bad to happen to Steve Bannon. Very interesting, Dan Goldman. Why is he instigating violence in America? Sounds insurrectionary to me. We also are going to take a look at some filings in the Steve Bannon case because a couple things just dropped recently. We already covered Steve Bannon's emergency appeal. The government has now responded to the emergency appeal, saying it's not an emergency. You can report to custody, get in there. And Bannon replied to that. A little bit of a technical read, but we'll go through it briefly and see what is inside this court case today. So Congress is fighting this. Liz Cheney is not happy today. We'll see if she reacts. And we have our next segment, which will cover Hunty Poo, because the House Oversight Committee, or one of the committees, released some new evidence that shows that Hunter was exploiting his vice president daddy. Joe was the vice president at the time. Hunter was under investigation. This took place back in 2016. And we're going to look at this letter from Hunter's counsel over to the investigators. And in it, they highlight My daddy is the vice president. Don't you know that? Everybody knew that, of course, but they're putting leverage. They're saying the vice president is going to have a problem with this, and lo and behold, nothing happened. So the cover-up continues. Now the Oversight Committee and others are blowing the whistle on it. And at the time when Hunter was relying on his vice president daddy, he got out of things back then. Now he's relying on his president daddy to come in here and help him out on this. And so Congress is looking into this, digging into whether there was whistleblower retaliation against our friends Gary Shapley and the other whistleblower Ziegler, who were there helping to blow the lid off this whole thing. Otherwise, I think it would have been a non-prosecution agreement for Hunter, and they would have just buttoned this whole thing up. And then on our final segment, we're going to poke over back in Georgia and see what's happening here in this young thug trial, because we have this attorney. He's a defense attorney. We happen to love our defense attorneys here. His name is Brian. I'm not sure what his middle name is, but I think he kind of looks like somebody whose middle name and the way he acts is maybe it's Balzov or something like that. I don't know. But Brian Balls of Steel is the defense attorney in this case, and he's dropping off these motions. And one of those motions is a motion to recuse this judge. And there's been a lot of activity on this case that's been very fast paced. But this motion to recuse summarizes all of the things that has been happening in this trial. And so it is a very nice package to explain exactly the problems of this corrupt prosecution. So we'll go through that. We'll read through it. It is amazing. So judge denied the motion. We'll read through it and see what's going on. But it's just amazing because this guy actually, if you're unfamiliar with this story, you're probably familiar with it. But he actually went into custody, right, in this case for, I think, a short time before the bond. Did he actually go into custody? I could be misspeaking right now. But the judge ordered him into custody. Whether he actually went in or not, I don't know. But he ordered him into custody, and I think he did. So anyways, we'll go through it. We'll see what's in it. They're going to give us the full background on this. So many of us are not up to speed on this story. So we'll get the details of exactly what happened in this motion to recuse. We'll read it together, and we'll see what's going on there. So, all right. So I don't. His middle name, it could be Manov. It could be Manov. I don't know, Manov or Balzov, Manov. I don't know. Pick one. But an amazing case. So we'll go through that today in our third segment. All right. Anyways, so we'll go through that one. We've got 3 amazing segments to get to today. Very grateful you're here and with us. It's a beautiful and incredible Tuesday. Hopefully your week is unfolding nicely. When we're done here, we are going to go over to... He was in custody. Yeah, that's what I thought. Okay, I was misremembering. I don't want to speak out of a turn. We'll read it together and we'll see what goes on. Anyways, all right. WatchingTheWatchers.locals.com, our members-only community. We do streams in the morning. We do streams on Saturday. We'd love to have you come and join us. So come check it out. And we'll see you there in our members-only after party as soon as we're done here on this stream. We've also got our website, robertgovea.com. So all the PDFs that we go through here on the channel, we post over there so you can download those and read through them at your leisure. We have our merch store. We have our calendar. We have our various show reports are also listed over there. So check it out. Love to have you join our website, join our newsletter. And lastly, come join us in Las Vegas, happening June 29th, 2 days after the first presidential debate. We're going to have a beautiful lunch and a watcher meetup in Las Vegas at Trump Hotel, and it's going to be incredible. We've got, what's on the menu? We got some chicken. We got some salmons coming up. I think we've got some, I don't know, there's a bunch of stuff. Oh, chocolate eclairs for dessert. It's going to be just fancy as can be because it's Trump, baby. So come check it out. WatcherLodge.com. Get your tickets at WatcherLodge.com, and we'll see you over there. We got a bunch of people registered. I'm super excited to see everybody, to meet everybody. It's going to be fun. And Mama G is going to be there, so you're going to meet her too. All right, so let's see what's going on in the house with our first segment, because this is some fun stuff here. Congress now has some momentum fighting to reverse a lot of Liz Cheney's J6 shenanigans because it was illegal in the first place. Illegally constituted under H.R. 503, they created a fake committee that didn't even comport with their own rules. And now they've issued a bunch of subpoenas. Of course, people that we've covered here, like Peter Navarro, is already in prison. And Steve Bannon, they're attempting to send to prison. And so the question is, what can this Congress do since this Congress is not in control of Liz Cheney and Nancy Pelosi? It's now in control of the Republicans, supposedly. So we'll go through and see what they can do. One person has a solution in mind. It's Representative Eric Burlison, who has a bill to reverse the subpoenas that Bannon got, maybe freeing him from the illegal prosecution, from the illegal HR 503 J6 committee. We'll have reaction because the Democrats really want him in jail, maybe so something bad can happen. And we'll take a look at Bannon's actual written appeals and his reply to Jack Smith's opposition. To the government's opposition here in a second. But first, this is curious. Representative Eric Burlison is the person who wrote this tweet. And on this tweet is this link. Well, for whatever reason, I didn't post the link in there. So we're just going to go grab that link and see what it looks like on Representative Eric Burlison's account and go through it because he had a nice tweet thread that for whatever reason I did not paste like a doofus. But here it is. Here is what Representative Eric Burlison wrote. He says, as a representative from Missouri, talking about the illegal J6 committee, he says, next week, I'm introducing, that's this week, a resolution to rescind the subpoenas issued by the illegitimate, so thank you for saying that, thank you, J6 committee for Steve Bannon, Mark Meadows, Dan Scavino, and Peter Navarro, and to withdraw the recommendations finding them in contempt of Congress. Sounds great. And I have not heard a lot of this language from many Republicans, so I'm very grateful to hear that, because many of them just presume it is legitimate. They just, well, Congress acted and the DOJ, if a process happens in front of them, they don't question it at all. They just get a result. It's like they get a ticket from a police officer. They say, wow, that's great. I must have been completely doing exactly what you said. Thank you. Wow. And a lot of Republicans are like that. What are you talking about? The DOJ return an indictment and you think it's legitimate for some stupid reason because Liz Cheney was involved? What? So he calls it illegitimate because it is. They're literally in violation of their own rules. But when they brought it up in court, what did the court say? The DC court said, we can't regulate Congress. There's a separation of powers problem. So if Congress wants to conduct their own illegitimate procedures, they're free to do that, essentially. And the Republicans didn't do anything in Congress, and so Pelosi just got her way, as she usually does. So he continues, he says, the committee was nothing more than a political witch hunt to blame President Trump and his advisors for the events that took place on January 6th, which were instigated by the feds and allowed to happen by Nancy Pelosi and the House Sergeant at Arms. Ask Stephen Sund about it. His advisors for the events that took place on J6 and to influence the 2022 midterms. And honestly, they tried to impeach him for that too. And the 2024 presidential election. They wanted to impeach him. They wanted to make sure he could never run for office again. The committee was legally deficient in its composition and was more focused. It was, absolutely. You can read the rules. We've read them here. HR 503, the resolution that was passed by the House, said this is what the composition needs to be. They didn't follow those rules. Illegal. The committee was legally deficient and its composition was more interested in making fake videos. Yesterday, Karine was talking about cheap fakes and deep fakes, and that's exactly what they did. They spliced in audio into surveillance footage. They made it sound like it was a horrendous scene to exacerbate the emotion. They didn't follow the House rules at all. And then they deleted evidence after their investigation. They just exonerated, evaporated video recordings. Transcripts are gone. The subpoenas issued were insufficient because they were based on an illegal committee and they should be rescinded. And the contempt of Congress referrals based on those subpoenas should be withdrawn. So he says, thank you to the co-sponsors, Andy Biggs, Thomas Massey, Chip Roy, Ogles, Clyde, Gosar from Arizona, Bob Good, Hashberger, Bobert, Clay Higgins, Breachin, Mary Miller, Barry Moore, Luna's in the house, Eli Crane, MTG, Jim Banks, and others. Okay, looks like a bunch of others. Scott Perry, Dan Bishop, and Representative Cloud. What makes it illegitimate? They were illegally constituted. Good question, War Monitor. HR 503 said they had to have 13 members. They didn't. They had 9. Supposed to be 8 Democrats, 5 Republicans. It wasn't. It was 7 Democrats, 2 Republicans. It's a representative body. It's supposed to be representative. The minority party did not have an opportunity to appoint or nominate any Republicans, not a single one. In fact, who they did nominate were rejected. by Nancy Pelosi, and she shoved in Kinzinger and Cheney and called those Republicans. So it wasn't legitimate at all. Thankfully, Eric Burlison is doing something about it. And this is Marjorie Taylor Greene also supporting him, saying, all right, you know, I fully support as well, and I'm co-sponsoring this resolution to rescind the subpoenas for Steve Bannon and Peter Navarro by repudiating Pelosi's illegitimate J6 committee. Says Nancy Pelosi violated House rules by refusing to accept McCarthy's appointed Republicans on the committee. Now our Republican-led House must nullify any actions taken by them because they're illegitimate. So you're going to hear a bunch of people on the left saying, no, they were perfectly legitimate. Congress is over. It's closed. Game over. So there's finality to the subpoenas. In other words, this next Congress cannot do this. But what if the prior committee was invalid? It didn't follow House rules. You can just do that, or maybe that it should be against the House rules. So we must also hold the J6 committee members accountable. That's absolutely right. They destroyed evidence in violation of House rules and the committee records. House Republicans need to start taking action. I hope they do. And I agree completely. Now, I don't know if that destruction of records will be something that's protected by legislative privilege or something like that. But you could make the argument that those documents were no longer theirs. They should be transferred over to the next Congress. So they had no right to destroy them at all. It's not their jurisdiction, in other words. It's the jurisdiction of the incoming Congress. So interesting. Now, I do think that there should be wide-ranging investigation for these people. This was a conspiracy. In my opinion, they created a lot of this. We know that in the Proud Boys trial, there were 50 identified government agents in the crowd, not only from the FBI, but also, which they admitted, they stipulated to that in the trial, but there were also Homeland Security agents that were also infesting the entire arena as well. And they were shooting people in the face with projectiles, blowing holes in their cheeks before there was anything going on to instigate a reaction from the crowd. And then they caused it to happen. And people like Ray Epps got away with it, even though he was at the first breach instigating the whole thing. So that is what the Congress is up to. Let's take a look at how the bill reads. This is what it would look like in Congress, submitted here. H-Res, this will be filled in eventually, but it tells us this is a resolution that would rescind the subpoenas from Liz Cheney's fake January 6th Select Committee that were issued on September 23rd, October 6th, February 9th, and withdraw the recommendations finding Bannon, Randall Meadows, Mark Meadows, Dan Scavino, Peter Navarro, all in contempt of Congress. They say on June 30th, Nancy Pelosi, then Speaker of the House of Representatives, established the Select Committee to investigate the J6 attack on the Capitol. Now, they tell us that the committee was deficient in its composition. The resolution that was H.R. 503 that was passed stated, this is the law. Okay, Congress passes the laws, and they pass their own resolution. Pelosi had to follow this order. The Speaker shall, see that? Not may, not if she's feeling happy or is drunk or whatever. Pelosi shall appoint 13 members to the Select Committee, 5 of whom shall be appointed after consultation with the minority leader. That was Kev McCarthy. Never happened. Speaker Pelosi refused to seat Republican members. Kevin McCarthy came in and he said, oh no, we're putting Jim Jordan on there. We're putting all these people on. And she said, no, I'm not putting those people on, resulting in a solely partisan exercise determined to vilify President Trump and his advisors for the J6 breach of the Capitol. And I don't know what the Republicans were really doing here. I mean, they were just allowing all of this to happen and just going along with it. Now, whereas Speaker Pelosi refused the selections of McCarthy, named only these 2 fake Republicans, Cheney and Kinzinger, to the committee. And the committee only had 9 people rather than the required 13. Isn't that convenient? And the Republicans, like all the media, just accepted it. It's not even real. They didn't even follow their own rules. And they just played it on TV day after day. It was pure propaganda. It was the shadows on the wall in Plato's cave, and most of the country just ate it up. Now, whereas the Select Committee held hearings, issued subpoenas, and published a flawed report without even the members required by H.R. 503, shortly before the hearings began, the Select Committee named Cheney as vice chair and operated without a ranking minority member. So there was no ranking minority member. The position of a vice chair is distinct and different from a ranking minority member, is clearly understood in the rules. We all know that. And H.R. 503 also, the rules specifically required the chair of the select committee to consult with the ranking minority member in certain circumstances. Never happened because there was no ranking minority member. Now, H.R. 503 included the requirement that the chair of the select committee could only issue a subpoena upon consultation with the ranking minority member. But the Democrats failed to draft and pass H.R. 503 in a manner giving the select committee chair unilateral authority to issue subpoenas. And so that's what happened. Okay, the Democrats just issued them. So all subpoenas issued by them are legally insufficient. They didn't give them that power in the rules. But everybody just accepted it. Now, Benny Thompson, then chair of the select committee, failed to ensure the preservation of the documents as well, deleted evidence, including documents, transcripts, interviews, video recordings of the interviews, all covered up. And the select committee also promoted numerous theories, didn't even interview people, and had no actual firsthand knowledge of these allegations. The select committee was also a partisan exercise from the very beginning. We already all know that. There was no cross-examination. There was no cross-presentation of evidence at all. For nearly 2 years, the J6 committee presented their own little book reports. Liz Cheney and her crayons came out, and what happened next? And they just read from the teleprompter on the thing that some other idiot wrote for them. And people started to tune out by episode 7. We're like, again, this is the same story again? His advisors and supporters in an effort to influence future elections, right? It's future rigging, and it was political prosecution. Now, whereas members of the J6 committee actually withheld and destroyed information that could have provided evidence that Trump did not engage in an insurrection, they deleted it on purpose. And then they imprisoned Peter Navarro, and they're intending to imprison Steve Bannon as well. They're trying to silence and marginalize political opponents and to chill the prospect of other people speaking out. Because if you speak out and you serve in the Trump administration, maybe you go to prison too. And remember, Bannon and Navarro were just invoking Trump's executive privilege. They were doing it on behalf of Trump. They worked for Trump. And so Trump said, no, we have privilege. You can't go talk about all this stuff because I'm the holder of the privilege. And so since all of that has happened, and still many Democrats in here think, no, totally legitimate to run a government this way. No, absolutely makes sense. Rob, H.R. 503, the House resolution that has these numbers like 13 and 8 and 5, they're just like guideposts. They're just like recommendations. It was legitimate because the Republicans had Liz Cheney on it. It's wild that they can rationalize that in their pea brains, but they do. But resolve, they say, all right, it is the sense of the House of Representatives now, this current House, that the select committee to investigate J6 committee was illegitimate by their own rules. That the conclusions and the findings that were presented were predetermined, obviously, due to the committee's partisan nature, and that the courts should set aside any convictions and commute any sentences stemming from contempt reports issued by the select committee. Now, the DOJ will take this recommendation and flush it right down the toilet, right? So Congress would pass this and they would say, it's partisan. So this would go over to Biden's DOJ and they would just dump it in the trash. But this would be very persuasive for Trump's DOJ. He comes in and he says, all right, everything is commuted. This next Congress has found that the first Congress was completely illegitimate they didn't even follow their own rules. It's objective. You can just look at the committee, look at the videos. How many people were on there? Was it 13? No. The subpoenas issued on September 23rd for Bannon, Meadows, Daniel Scavino, Navarro, they're all hereby rescinded if this passes. And of course, this would be, you would ask, well, does this have to pass the Senate too? Well, I don't know. I don't think so, because it's just the House governing itself after all. And the courts already said that the House can kind of govern itself. And if H.R. 503 passes the House and then Pelosi acts like a lunatic and violates all the rules, so be it. So, okay, just do what they did. H.R. 730 recommends that Bannon, they find him in contempt, right? So they're going backwards to the prior Congress, recommending that the House of Representatives find that Bannon be held in contempt is hereby withdrawn, dismissed, or otherwise ended and concluded without further proceedings or enforcement. And HR 1037, which held Navarro in contempt and Scavino in contempt, is also withdrawn, dismissed, or ended. And the HRES finding Mark Meadows in contempt from December 2021 is also hereby dismissed. And we now notify the Department of Justice that the subpoenas are hereby rescinded and shall be considered null and void. So this would cause a problem, right? If this happens, if this passes the House, and it absolutely should. What Republican out there is going to have a problem with this? They have a perfect justification. Even if they don't like Bannon or Navarro or Trump even, just say the House has to follow rules, okay? HR 503 was the rule. We agreed to that. They broke their terms. So that is the base layer. Can you just ask the Democrats to follow the rules? Republicans, like, how complicated is this? Or is it just total bedlam in your own body of government? So they should all be passing this. It should pass clearly, unequivocally. Every Republican should sign on to it. It should pass quickly. And then we'd run into a problem with the DOJ. They'd say, nuh-uh, the other Congress already said it was. And so we've already instituted our prosecutions. And of course, the DC courts would probably agree with them. But then you'd have some appealable issues. And then Trump would have a nice pretext, a nice basis for going in and reversing all of this stuff by just ordering his DOJ to stop the prosecutions and make other recommendations for early, Bannon would be out by then, but for release and for commutations and for pardons, quite frankly. So we'll see where this goes. That got submitted. There is support for it. Want to play a couple of these clips before we see what Bannon says about this in his filings. But here was the media just giddy that Bannon might be on the verge of going into custody. And as we've talked about here, this is going, I think, to backfire bigly on them. They're giddy about prosecuting their political opponents. And I think it makes a lot of people's skin crawl to recognize that we're living in a country that is now deviating, descending into this era. So here is CNN having a fun time with this, almost giddy that Bannon might go into custody.
Breaking news, Steve Bannon denied his request for the so-called Club Fed when he's forced to report to prison. Sources telling CNN that the longtime Trump ally will not get a cushy prison assignment, but is likely to serve time in a Connecticut prison where he could be placed with violent criminals and sex offenders, a prison that does not have individual cells, but rather an open pod layout for inmates. And CNN is learning tonight that there is also a chance Bannon could be sent to New York City's infamous Rikers Island. Breaking news, Steve.
Amazing. So they're like really happy about, where's he going to go? Where's he going to be? And almost excited. You can see a little bit of glee in her face. And so that is CNN. Now, remember that they've told us that if you say bad things about a person, so for example, if Trump says something about a judge's GF who used to work for Chuck Schumer, who hates Donald Trump, who donated against him, all the things, then Trump is intending to cause violence to that person. Okay, when Trump comes out and Trump says the feds wanted me dead because there was a legitimate use of force policy that they incorporated into their raid at Mar-a-Lago, which is all true, then Trump is engaging in stochastic terrorism. He's trying to hurt the feds. He's trying to hurt the FBI agents, right? They cry about it all the time. So now Dan Goldman, I guess, is allowed to do that. So he's going to say that Steve Bannon, who's about to report to prison, Steve Bannon's a private citizen, by the way. He just has a really, really great podcast and show that everybody happens to love, which makes him a big threat to Dan. But Dan is now encouraging, I think, by this language, playing by their own rules, if he's going to talk about what a bad dude Steve Bannon is and how dangerous he is to democracy, is he intending for something bad to happen to Steve Bannon? Are the security cameras also going to fail like they did for Epstein? Are the security guards going to fall asleep and someone's going to come and deal with the insurrectionist who already almost ended American democracy? How is Dan Goldman, the man who bought his congressional seat because he inherited a bunch of money from his Levi Strauss family, what is he is he going to be held responsible for this stochastic terrorism?
New York Democratic Congressman Dan Goldman. Congressman, thanks so much for joining us.
Here, let's play that again with a higher volume here.
And joining us now is New York Democratic Congressman Dan Goldman. Congressman, thanks so much for joining us. We appreciate it. You know, when you listen to Steve Bannon say things like November 5th is Judgment Day.
That's right.
January 20th, 2025 is Accountability Day. I mean, you can write this off as that there goes Steve Bannon again. But after January 6th, you can't really do that. What's your reaction when you hear that?
Because there's going to be another insurrection.
Remember, Steve Bannon was the one on his podcast the day before January 6th.
Shout out to War Room.
Really rallied the troops, so to speak, to raid the Capitol. And now he's using the same rhetoric. So it's the same as Donald Trump. It's one thing if you do it the first time and you don't necessarily realize what the reaction will be. It's entirely different when you know what the reaction is to your violent rhetoric and you still continue to do it. So let's not make any mistake here. Steve Bannon knows exactly what he's doing. He is riling up a violent base that is the same base that invaded the Capitol, and he is saying victory or death, which means either we win or we kill our opponent.
That's not exactly what that means. It sort of means like you die trying, like you don't have to kill your opponent. You just kind of die trying kind of a thing. And it doesn't also necessarily mean actual physical death. It's like we're going to work ourselves to death, right? We're going to kill ourselves to get this thing accomplished. You know, so I'm saying like that. So, of course, we know Dan Goldman has used some very colorful language in the past that he had to apologize for when he said he wants Trump eliminated. He wants Trump taken out. That was a big problem for him, but now he's, I guess, smearing the other side. Our side, you know, victory or death means that you're just going to fight aggressively. It's a phrase that the founders use and many people in political movements have used for all eternity, right? Give me liberty or give me death, right? We've all heard that phrase. We know that. Maybe Dan Goldman hasn't, but that is an American phrase that has been incorporated into our body politic for centuries, Dan.
That is the definition of fascism.
Not really.
And it is incredibly scary, Jim, to think that this is what we are facing in this next election. I don't want to talk about policy.
Of course
we
not.
can talk about policy, you know, all day long, but it's irrelevant. What we have is Steve Bannon and Donald Trump trying to destroy the country that we know.
Well, so it feels to me like Dan Goldman should be gagged, like which he might like, but he is wanting to, I guess, silence Steve Bannon because Steve Bannon is an insurrectionist. He's a private citizen who's now going into federal custody. We have a sitting congressman on national TV news who's saying this guy tried to end America. It's almost like he's blowing a dog whistle, as they say, to maybe cause some stochastic violence on Steve Bannon, alerting all the maniacs who watch CNN that Steve Bannon might be going into custody. Maybe somebody will do something about that, Dan. Pretty disgusting behavior. Maybe the FBI should investigate him. Now, here is some new filings in the Steve Bannon case. We know we've covered this previously here on this channel that Steve Bannon has submitted an emergency appeal to the circuit court to try to get a stay on the order to put him back in custody, to send him into custody. And we read through that full filing here previously. So if you missed that video, certainly check that out. But now we have two additional filings in response to that. So the way these go, Bannon makes the first motion, government responds with their response, and then Bannon replies. He gets the final say, like the final slice of bread on the sandwich. We've already read through Bannon's first attempt filing. This is the government's response. We'll hit the highlights on this and then see what Bannon says in reply. But this is from the government. Now, remember, we're in the District of Columbia. This is not Jack Smith. This is just a regular old DOJ. They say after this court affirmed Bannon's convictions, so Bannon appealed, the court said your appeals are invalid. Then the district court said that they lifted the stay of Bannon's sentence. Okay, so the Court of Appeals comes out. Bannon says we're going to appeal it again, but they then lifted the stay. Now, Bannon has filed an emergency motion, so he's got to go back into custody. But they say that Bannon fails to show why he should have a reversal or a new trial. They say this court already knows all the facts. All right, January 6th attack happened. The illegal J6 committee issued a subpoena for Bannon, and they say that he might have information about J6. The subpoena listed 17 categories in their fishing expeditions. The vast majority of the topics listed Bannon as a private citizen, and Bannon did not comply with the subpoena. So then they got a letter from Justin Clark, Trump's lawyer, that said Trump was invoking executive privilege. And the committee, Liz Cheney and Benny Thompson, illegally constituted. They rejected, not the courts, the executive privilege claim. It said, no, we haven't gotten it from Trump, and it's not going to excuse you of this. So Bannon insisted that the committee doesn't have subpoena power. But then they learned that he was refusing to comply. They sent him a letter. Bannon still refused to comply. And the court then, he was ultimately referred for contempt prosecution. He was charged. They tried him before a jury. He got 4 months prison, and the district court stayed the appeal, the sentence pending the appeal, so he didn't have to go into custody. Now, this court, the D.C. Circuit Court of Appeals, affirmed Bannon's convictions, rejected his claims that there was no mens rea element, because he wasn't intending to violate the law. He thought he was in compliance with the law. He was honoring the executive privilege of Trump. The court said, no, we think that your conviction is warranted, and they say that Bannon should go into custody now. If he wants to get released, well, he has to show that there's clear and convincing evidence that the appeal is going to raise a new question of law or fact. And Bannon's going to respond here in a minute and explain, oh yeah, there's tons of stuff to dig into. They say Bannon argues that the mental state required for contempt requires and presents a substantial question that justifies a rehearing or a rehearing en banc to go to the full Court of Appeals. But he doesn't establish why that is. And they're going to give us a lot of background here. A substantial question means this. And so this is a technical argument. They're saying in order for Bannon to get a pause on this, he's got to show that if we had this trial again, there was some error that took place that would reverse the result. You don't just get a stay unless you can show there's a really good reason for it. So they're going to explain why there's not a need for a stay here. But let's fast forward and see what Bannon said in his response, in his reply. So from Bannon's defense, he's now replying, say, oh, no, we've shown plenty already, okay? The D.C. Circuit Court of Appeals should absolutely hear this claim and stop Bannon from having to go into custody. They tell us, first of all, under the law, Bannon only needs to show that this appeal would present a new substantial legal question that, if accepted, would result in one of two things. So Bannon, what does he have to do? Would likely result in a new trial or less prison time. And so therefore, he's entitled to do that. Saying the various sections of the law require two-part inquiries, and contrary to what the government said here, all circuits have concluded that it's not about committing reversible error. Okay, it's not that high of a standard. It's a much lower standard. The statutory standard is lower. Unlike someone seeking a stay pending appeal, Bannon need not show that there is a fair chance that the Supreme Court would actually grant review. That's not the standard. It's lower than that. Now, the mindset, right, the guilty mind issue, it remains a substantial question. This is the mens rea issue. Did Bannon actually knowingly violate the law? No, he thought he was in compliance with the law, honoring Trump's invocation of executive privilege. And if that position is accepted, Bannon would likely be entitled to a new trial. And even if Bannon did not make a showing, did need to make a showing that the Supreme Court would be interested in this, he's already done that. This is a big deal. They say the government claims that Bannon can no longer show this and that they've already rejected his arguments. But they say, no, that's not true. The government previously made the opposite argument. And they said that even the OLC memo has never addressed a situation resembling Bannon's. This is a new issue. The novelty here even exists in the OLC opinions. Even they've never seen a situation like this, where an outgoing president invokes executive privilege on behalf of a prior administrative official. And second, the panel opinion also stated that the Supreme Court's general rule about interpreting the word willfully, did Bannon willfully violate the law? It would match Bannon's interpretation. In other words, if the Supreme Court simply adheres to its general rule, Bannon must get a new trial, because willfully means, like what it sounds like, willfully wanting to violate the law. Bannon had no intention of doing that at all. He was following advice of counsel. Now, the government's only argument to say that Bannon willfully, they just say it means intentionally, right? So he intentionally did the thing. Like, did you move that thing? I intentionally moved the thing. I intentionally took the act, which you would say could be lower than willfully. But it contradicts their own standards of construction. It's in serious tension with its Supreme Court's own decisions. Now, the court's panel also recognized these other cases, defining what does willfully mean. It's difficult to imagine the court concluding that the mens rea, the mindset requirement, for two different provisions which use starkly different terms are identical. In other words, it'd be weird to say that willfully and intentionally are the same thing, because they're not. They used both different words in two different sections, so they mean different things. Supreme Court has recognized this, and so Bannon is entitled to that argument. Now, to the extent the Supreme Court has already addressed this, Bannon he's at least demonstrating this is a substantial issue. What is the distinction between the two? We also think there's a good reason that the Supreme Court is going to hear this case eventually. We don't think he does need to prove that, but we think that they will hear it. The Supreme Court has already granted nearly 20 cases on this section of the law, saying the government claims the court hasn't granted one in decades, but that's only because the government stopped pursuing these convictions until Trump came into power. The government resurrected this claim, and there is every reason to believe the court will want to address this anomalous mens rea holding. And so we're waiting for SCOTUS to step in. Now, as also noted, a few Supreme Court cases also favor Bannon. The Supreme Court routinely grants review of lower decisions that are in tension with its own decisions. And third, there's serious concern about politically tinged prosecutions under this law. It's far more of a practical concern, saying that the theory is that the defendants will manufacture a claim of good faith. Now, the government argues it's unlikely there will be such prosecutions when officials actually do invoke executive privilege. But that memo supports Bannon's request because it shows that the OLC will actually defend those prior cases when intentionally comes into play. Now, for all these reasons, there is a strong basis that the entire Court of Appeals, en banc, or the Supreme Court may step in and shut this Pandora's box. So there's a good reason for this appeal to move forward. Now, even if this court considers the odds of further review to be both relevant and low, the court should still allow Bannon to be granted release. Okay, Bannon, no prior prior criminal convictions that we're aware of, and he served his country. He's not a flight risk, right? He's got an entire business and community and audience here. He's working to fight for this country, worked for the former president. So why would he need to go into custody now all of a sudden, pending appeal? Well, it's so that they can silence him, so that he's not on the air talking to his amazing audience between now and the election. Now, other courts have explained, even though the court considers the likelihood of granting cert, the Supreme Court accepting this case, the court does not relish the prospect of revoking bail and putting him in incarceration only to have the Supreme Court reverse this. And the mens rea error is not harmless. They made a big mistake. They created an enormous error in the mens rea instructions. The government claims that the preclusion of advice of counsel evidence that Bannon was relying on his lawyer, he couldn't even make that argument to say, my lawyer told me I couldn't do that. They say those are not harmless. That position is meritless. Big deal. Which is why the government never raised it during a direct appeal. This court has already held that eliminating the prosecutor's burden of proving mens rea, a guilty mind, is a serious constitutional error. And error cannot be harmless where it prevents the defense for providing an evidentiary basis for his defense. And that's exactly what happened here. The district court in the trial stopped Bannon from presenting a defense at trial. And they instructed the jury consistent with their other rulings because he got railroaded just like Trump did in D.C. It's not any different. The government points to the record, but only the record the jury heard was that Bannon had disregarded the subpoena and he couldn't even talk about his good faith reliance on his lawyer. So Bannon, how could you say that he willfully or intentionally did the thing if you say my lawyer told me not to? I talked to counsel. They said it's illegal if you do this. You are legally immune from doing this. He followed their advice, couldn't even tell the jurors. Now, the government argues that even if Bannon prevailed on his separate argument about the disputed test for substantial review, it would not likely result in reversal. But if Bannon were in the Ninth Circuit with its lower test, he would remain out on appeal. And by forcing Bannon to instead serve his entire sentence before his appeals are even completed, the government is precluding any opportunity for him to serve less time, and that satisfies the law. And so this court should grant this motion. And by the way, the government argues that Bannon, quote, never raised executive privilege as an affirmative defense. But that's a red herring. It's undisputed that Bannon has argued at every stage of this case that his conduct was not willful. And the reason why it was not willful is because he relied on advice of counsel, who believed that Bannon could not lawfully comply with the subpoena until the executive privilege issue was resolved. So a good filing. This is submitted by Trent McCotter, Boyden Gray, PLLC law firm. And they send that in on behalf of Steve Bannon into the D.C. Circuit Court of Appeals. Now, we're not optimistic that this is going to go anywhere, but we'll see what their rejection looks like and whether the full court will accept it en banc or whether they'll get rejected and then take this up to the Court of Appeals. Time will tell. But this is what the Congress is doing, seemingly making some progress in creating some momentum to undo what the J6 committee did. They were illegally constituted. It's like fruit of the poisonous tree. If you have an illegal search of a person's vehicle or home, guess what? You lose the evidence that you seized. You don't get to now use those drugs against that defendant because you violated his constitutional rights to go in and seize that property. Same thing here. Everything the J6 committee touched was created out of an illegality by their own rules. It should all be thrown into the garbage, which is what the voters of Wyoming did to Liz Cheney. Rightfully so. So we'll see if Congress does anything about this. Hopefully Mike Johnson takes this up and passes it since they're in control, theoretically. We're going to be here continuing to cover this, my friends. Thank you for subscribing wherever it is you're watching this. We'd love to have you come back here and join us. We cover this type of stuff very regularly and would very much appreciate having you become a member of our community over at watchingthewatchers.locals.com if you want to get some extra members-only content. But if you enjoyed this video, we have a great segment coming up next on Hunter Biden and the way that he used his vice president daddy to escape his own criminal problems. We'll see you back over there on the next one. All right, my friends, but we're live now here, so let's carry on because we've got Hunter and daddy. Hunter Biden called his daddy and said, I need help. And Joe Biden loves to talk to him very regularly. And so since they're so close, Hunter apparently thought it was perfectly appropriate to invoke his daddy's name in an email where he's negotiating with federal investigators over criminality, over criminal probes. Hunter says, don't you know who my father is? And lo and behold, nothing happened. Now, Joe Biden is the president, and now his DOJ is allegedly also putting pressure on the whistleblowers who blew the lid on the Biden crime family earlier. So Congress wants to know what the Biden DOJ is doing to attack those whistleblowers, while Congress is also simultaneously releasing evidence of Hunter Biden's collusion with his vice president daddy. And so let's see what the Oversight Committee released here. In their report, they said, Hunter played the dad card in the SEC in violation, saying in 2016, good old Hunter was subpoenaed by the U.S. Securities and Exchange Commission, for information in its investigation of a tribal bond scheme in which several individuals were charged with violating federal securities laws. Now, we obtained Hunter Biden's response from his lawyers that were dated back in April 2016. We'll read it in a minute. In the letter, they tell us that Joe Biden is Hunter's daddy. On May 16th, the SEC published a press release announcing the charges of 7 individuals with no mention of Hunty Poo getting charged at all. Isn't that convenient? So here's the letter that Hunter and Dad sent over, Hunter and lawyers sent over referencing Dad. You see, this is a confidential treatment requested pursuant to this U.S. regulation. This is from so-and-so via email, these titles, looks like a Washington, or maybe this is it's probably a watermark from the Oversight Committee, so that watermark on top looks like the Oversight Committee watermark. Yeah, it is, Oversight. All right, so that they stamped it. This is April 20th, 2016, and the people who are writing this are redacted. Sincerely, Hunter's lawyers, copying a U.S. prosecutor, assistant U.S. attorney, and it's dated April 20th. So Trump is not the president yet. Joe Biden is the president. It's 2016, but Trump has not won the election yet. Here's the conversation. Dear U.S. Securities and Exchange Commission, on behalf of our client, Robert Hunty, enclosed, please find documents Bates stamped RHB this section through this section. So some materials that are responsive to your subpoena issued in the above caption investigation, missing a G there. Now, as didn't even proofread his, they don't care. They didn't even proofread. It's like, get the hell out of here. My daddy's the vice president. Get out of here. Not even spell check. Now, as a threshold matter, we request that you treat this matter with the highest degree of confidentiality, consistent with commission policy and applicable law. Now, the confidential nature of this investigation is very important to our client, Hunty, and it would be unfair, not just to our client, but also to his father, the vice president of the United States. Miss SEC. If his involvement in an SEC investigation and a parallel criminal probe into Hunter were to become the subject of any media attention, don't want that. So please be advised that notwithstanding the subpoena's definition of Rosemont Seneca Bohai LLC, as it's including its affiliates, officers, directors, and employees, Mr. Biden Hunter's production of communications concerning RSB, Rosemont Seneca, is limited to emails that he sent or received or on which he was copied, given the fact that the subpoena was issued to him personally. The production does not include all communications with Devon Archer, the purported sole member of RSB. Now, please also be advised that we are continuing to review 2 potentially privileged documents that we're not going to send to you. In the near future, we anticipate either producing these documents or withholding them subject to a privilege log. Now, in response to instructions number 14 and 15 in your subpoena, at Mr. Biden's instruction, Joan Mayer and Eric Sherwin of Rosemont Seneca searched the offices for hard copy documents, and they also searched, so these are Biden people, right? Eric Sherwin is Biden's like COO, basically, Joe Biden, and searched Mr. Biden's RSA email account using search terms derived from the portion of the subpoena describing what documents should be produced. So it's like their agents investigated themselves. They were probably also shredding everything that they could find. These documents were reviewed for responsiveness and privilege by Mr. Biden's outside counsel. I don't know why the FBI didn't raid his residence. I don't know. Original documents are maintained at the offices located at this address. Mr. Biden believes he's met his obligations. Now, all letters and documents produced to the staff are provided solely to the FEC for its use in the investigation. We ask for confidentiality pursuant to FOIA, make it non-public, and we request that any materials provided be returned to the undersigned after the investigation is completed. We understand that upon receipt of FOIA, if the SEC determines there is no ground to withhold, that you'll seek substantiation from the firm to afford continued confidential treatment. So if somebody wants this material, you'll let us know when they come poking around for it. So there it is. Hunter talking daddy. My dad's the vice president of the United States. And guess what? Nothing happens, as they've just explained to us. He gets investigated and they come out. They charge everyone else except Hunter. Isn't that fun? So his dad was the vice president at the time, protecting him back then. Now they're protecting him by going after the whistleblowers when his dad is the president, supposedly. We are investigating now, says the Oversight Committee, whether the U.S. Office of the Special Counsel has contributed to the retaliation of the whistleblowers who blew the lid on the Biden crime family, Gary Shapley and Joseph Ziegler. Says the whistleblowers Shapley and Ziegler blew the whistle about the misconduct, not only of the Biden crime family, but by the DOJ, by the FBI. Okay, we know the Bidens are criminals. That's fine. It's terrible that they're leading the country right now, supposedly, but it's expected. The DOJ also covering it up and instigating it and warning his lawyers is a whole separate level of problem. They did exactly what an honorable government employee should do, Ziegler and the whistleblowers. They witnessed the wrongdoing. They reported it responsibly. They made legally protected disclosures. But sadly, Shapley and Ziegler have faced retaliation for doing the right thing. Now, the Office of the Special Counsel is tasked with protecting these whistleblowers, and they must conduct an impartial investigation of the claims without improper influence. And so we are now demanding a briefing to determine whether there has been improper influence in their claims pending before the Office of the Special Counsel. And so this is the latest from Congress. The whistleblowers are under attack. Congress of the United States drafted here, signed by Mike Johnson, Speaker of the House, Steve Scalise, Majority Leader. We got James Comer's on the list, Jim Jordan and Jason Smith, Oversight, Judiciary, and Ways and Means, all signing this one, saying, all right, listen here, Miss Karen. All right, Karen, Acting Principal Deputy Special Counsel. All right, listen up, Karen. Gorman. The House of Representatives, including all of the committees we just talked about, are now investigating the Office of Special Counsel. We think that there was retaliation against these IRS special agents Shapley and Ziegler, the whistleblowers. Now, needless to say, if there is retaliatory behavior, that would be contrary to your primary mission, which is to protect them, if you forgot. Now, the House Republican leadership and the committees request a briefing, and it's the Speaker of the House now, to better understand the Office of Special Counsel's conduct to ensure that there have not been any improper influence on your investigation. Says Shapley and Ziegler both have whistleblower retaliation claims pending before your office. Now, in particular, Shapley made protected disclosures about the Office of the U.S. Attorney from the Delaware District, alleging that David Weiss committed prosecutorial misconduct. And then he says that Weiss, as soon as he started to blow the whistle on this thing, Weiss began retaliating against him in November when he learned about the disclosure of his office's wrongdoing. And so on March 11th, David Weiss filed a redacted document related to the whistleblowers with the Central District of California. It was placed on the court's public docket. Now, the phrasing of and the redactions to the filing have led to media speculation about the whistleblowers themselves are under investigation for wrongdoing. However, the committee now understands, based upon information provided by the lawyers for the whistleblower, that they're not under investigation. Rather, it is the OSC that is investigating the whistleblowers. It's not the DOJ, it's the OSC. It appears that the Office of Special Counsel specifically requested that the information be filed with the court under seal, which necessitated the redactions to the public version. So the whistleblowers go to the OSC, hey man, we got a problem. You guys are here to help us. Let us report this to you. And they say, oh, well now you're under investigation too. The committees are concerned both about the OSC's request and the nature of the subsequent redactions because they were interpreted by many to reflect negatively upon the whistleblowers. Now, the committees were also surprised to learn that the OSC did not take any meaningful action for nearly 2 months to correct this impression. We understand that the confidentiality of the whistleblowers is of the utmost significance, but when there's a public filing by the very government official accused of retaliating against them, the committee seeks to understand why you did nothing to mitigate that harm and to correct the public record. And so relatedly, President Biden also announced his nomination of now Special Counsel Hampton Dellinger. When they did that, U.S. senators expressed deep concern with his ability to investigate these specific issues. Okay, so Joe now appointed another special counsel who used to work at Boies Schiller with Hunter Biden. So So just to be clear about how this is working. So we have the Office of the Special Counsel, and the whistleblowers, we'll call them here, the whistleblowers, Shapley and Joseph Ziegler, they come as the whistleblowers, they report to the Office of Special Counsel. Now there's questions, right? And they were working on David Weiss's team. So they were with David Weiss, who was the actual special counsel investigating the Hunter Biden claim. So the whistleblowers now blow this up, go to the Office of the Special Counsel, who assigns, and who does independent investigations. And they say, hey, this independent investigation with this special counsel is a problem. So then the OSC is essentially investigating the whistleblowers again. And now we know that Joe Biden just took the leader of the OSC, so this person who was currently in charge, and replaced them with this person called Dellinger. So then Dellinger comes in here, and Dellinger, and just to be clear about this, David Weiss over here was investigating Hunter Biden down here. This whole case is about Hunter Biden. So the whistleblowers are also investigating Hunter Biden, and they got deviated by David Weiss. So now we know that this Dellinger person used to work at a law firm called Boyes Schiller, which did work for Hunter Biden. See that? Isn't that amazing? So the whistleblowers are now going to be reporting to an office that's led by somebody who used to work for Hunter. Great. Good job, Joe Biden and the Democrats. So he worked with Hunter Biden on various Burisma matters, which is exactly what they're investigating. So while the committees recognize that the special counsel Dellinger has recused himself for this matter, the committee still wants to ensure that there's been no improper influence exerted in these cases, including the decisions of the OSC related to the handling in this particular court filing, both before and after the media scrutiny. Accordingly, House Republican leaderships and committees request a briefing on those topics. If you have any questions, give us a call. Thanks for your prompt attention to this matter. Sincerely, your friends, Mike Johnson, Steve Scalise, and all the other things. So then they say, no. So he's recused himself. So there's a force field here. So actually, there's no connection at all. Not even working on the case at all. No influence at all. Oh, got it. Thanks. Just like Merrick Garland doesn't have any say over Jack Smith, except he does. That's why Jack Smith doesn't need to be appointed, because he's working for Merrick, except he's not. That's why there's independence. So it makes no sense, but it's corrupt. You can just see the diagram. We just diagrammed it all out. So there it is. Joe Biden makes the change. They're going after the whistleblowers. We're not going to let them do it. We're going to keep our attention on this stuff, keep reporting on these disgusting shenanigans, and we hope you join us as we do. If you like this video, my friends, we'd love it if you hit that subscribe button so that we didn't miss you on our next one. We've got a great segment coming up next. We're going to turn our attention over to what's happening in Georgia. This young thug trial is off the wall, and there's a new motion to recuse that we're going to dive into, and so we'd love to see you over there on that video. If you like this video, leave that little like button as well. We'd love to see that happen, and see you back here on the next one. All right, so let's get into it. We got one final segment on the day, and let's talk about it, because we've got this judge who's in some hot water. Yeah, this is crazy. Judge Glanville gets hit with a motion to recuse. It's brought by Brian Steele, who delivered it very casually in an ominous drop-off the day before we got to read the motion. This is what it looked like, a courtesy copy. Brian, middle name, probably Balzov or man of, is now dropping the motion off. It's a motion to recuse Judge Glanville, and it gives us a nice summary of everything that's happened in here. So if you're just catching up to speed on this trial, getting up to speed like we are, we're going to see what happened and assemble all the backstory before we hear how the judge rules on the motion to recuse. Now, this is the scene when Brian, man of Steele, came in and showed up in front of the judge and the courtroom and just very casually dropped off these filings. And they're masked up now because of some COVID exposure or something.
State and the court, but it's being filed as well. This is not a filed copy. Just a courtesy copy.
Everyone's taking a look at this. What is this? This looks fun. All right, now they're all realizing this is a big, big one. Motion to recuse. They're going to look through it, and it is quite good. So let's just dig right into it. The motion gets dropped off. Brian Steele, the Steele law firm, submits this one after just a wild ordeal. You see, we've got a bunch of exhibits, but Brian Steele, the Steele law firm out of Atlanta, Georgia, Keith Adams also joining in on this, signing off on it. Big filing, 27-pager, all in an attempt to recuse and to disqualify Judge Glanville from all further dealings in the above referenced case. It's a motion for a mistrial, which was goaded by the improper conduct committed in concert by the court and the prosecution. Whew, that is a fun title. So a lot of background on this is going to be incorporated into this filing. Let's see what happens. They say undersigned counsel, Mr. Brian Steele, represents Mr. Jeffrey Williams in this case. Now, the jury trial accused multiple persons commenced back on January 4th, 2023 in front of Judge Glanville, multiple felonies. The trial is expected to last at least through the end of 2024, this entire year. Now, on Monday, June 10th, within 5 days of filing this timely motion, this court, along with the prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness called Kenneth Copeland, for whom an order of use immunity had been issued on Friday, June 7th. So we have a meeting. There is an ex parte meeting. So the ex parte means it's between basically the judge and one party. It could be either the defense or the prosecution. In this case, it was the prosecution. So the judge, the prosecutor are meeting. They're not notifying the defense about this. This is a big problem. Both sides should be there. It's only ex parte for very rare things. And there was another person who was also in this. Now, normally ex parte meetings are just between a judge and a prosecutor, for example. Like we've seen these being used in the Florida classified documents case. Jack Smith's team will say, Judge Cannon, we got all this classified stuff. We got to show you, blah, blah, blah. So we can't show the other side. And so we'll just show it to you. She says, okay, fine, just send it to me. But what's also strange about this is they also brought in another sworn witness. Well, that's weird, because now the defense is saying, well, I want to have a record of what you talked with this witness about. So a sworn witness called Kenneth Copeland in there, who got some immunity, was also issued. So now they're talking to him about, I guess, the evidence of the case, and the defense is not there. So you're flipping out if you're a defense attorney. It's absolutely insane. So no notice of this ex parte meeting was provided to the attorney. So it's like they're all just having a little secret meeting with a key witness who has some immunity, and the prosecutor's trying to finagle some evidence against your client. No criminal defense attorneys that were accused in this case, for representing defendants accused in this case, were there. In fact, the accused and their counsel were in the dark that this, quote, Star Chamber meeting even occurred. Mr. Copeland had previously, so this is a witness testifying, previously been called to testify on Friday, June 7th. He comes in, he goes into court, he asserts his Fifth Amendment privilege in open court in front of the jury. I invoke my right to remain silent. I'm not talking at all. So then the judge held him in contempt, and they incarcerated him until such time as he agreed to testify. No, you have immunity, says the judge, so you have to testify, because they're not going to prosecute you for the bad things that you say. So you have to testify. You're going into custody. So then Judge Glanville and prosecutors, they essentially admitted by silence and by their statements in open court that an ex parte meeting occurred on the morning of June 10th, only after the undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. So then, right, this guy, the government wants him to testify and say certain things. That's why they gave him immunity. If you say these things, you're going to have immunity. We're going to love you, and you're going to make our case. He comes out, I'm invoking. Judge says, well, You're going into jail until you tell us the right thing. So then they glean that they had this ex parte meeting. So then the judge is putting pressure on him at this meeting. You better testify. Here's your immunity. They're not going to prosecute you for this, whatever. So the defense catches wind of this. At the earliest opportunity on the afternoon of June 10th, the court was informed, based upon information and belief, that the ex parte meeting with the sworn witness, Kenneth Copeland, and the prosecution occurred earlier that day. That the witness, right, so the defense team goes, oh my gosh, we now know about this. That the defense team had made factual admissions and that the statements made to the witness by the court and the prosecutor were acting in concert about the amount of time that Mr. Copeland could be held in custody on contempt. So if you don't talk, if you don't tell us what we want you to say, we're going to hold you in custody for a long time. The court denied Brian Steele's request for the transcript of the ex parte meeting. Said, no, you don't get to see what we talked about. And denied the timely motion for a mistrial based upon this improper ex parte meeting, which violated my client's constitutional and statutory rights, including the right to due process, to be a part of the process, to have a fair proceeding, a fair trial, a fair tribunal, ethical prosecutors in Fulton County. Yeah, right. And the right to be present at every critical stage of the proceedings under the Georgia Constitution. Mr. Steele continues. Uniform Superior Court rules delineate rules about ex parte communications, Judge. It generally prohibits ex parte communications, generally, except as authorized by the law or by rule. Judges shall neither initiate nor consider ex parte, your little secret meetings, by interested parties or their attorneys concerning a pending or impending proceeding. In fact, ex parte proceeding hearings are only authorized in cases of extraordinary matters, like temporary restraining orders and temporary injunctions, okay? You go to a judge in the middle of the day and say, my ex-husband's going to try to kill me. Well, I need to have him here so that he has proper notice. He's like going to kill me tomorrow. Okay, so we'll have just a temporary restraining order. It's he has a right to a hearing within 10 days, but we're going to grant it to you right now. We're going to have an ex parte proceeding. Obviously, he's not here. So tell me what happened. Okay, I'm going to grant this protective order. You go and enforce it. They'll provide notice to him and so on. So like you can do it, but it's in those types of situations. It's not when you have a witness and he's like, I'm not just going to tell you what you want me to say. In other judicial hearings, both parties should be notified of the hearing so that you can have an opportunity to attend. We have this thing in the Constitution called, the confrontation clause. Pretty important. It's an idea that you have a right to face your accusers and to be apprised of the process that's being brought against you. So they copy and paste a bunch of this, saying here, assuring fair hearings. Here's from the Georgia Code of Judicial Conduct. A judge should be a good judge, right? Don't be a conflicted, bad judge who has ex parte communications with people. It's going to disadvantage one side. So we'll fast forward through that and see how he explains it. But the court violated the judicial code. The court has joined the prosecutor's team, working against the defense, is biased against Mr. Williams, and favorable to the prosecutors as demonstrated throughout the pendency of this case. Saying the reason why this should all be granted, a recusal, a mistrial, and more, says the trial court rejected our arguments for information about the unlawful meeting, and you also denied our motion for a mistrial. We made those arguments. Instead, Judge Glanville stunningly demanded to know, so he comes out, Brian Steele, says, Your Honor, we know about this meeting. I want to know more information. Give me the transcript so I can read about it. The judge flipped, said, how did you learn about this ex parte meeting? I want to know right now. The prosecutors stunningly sat mute. They permitted this injustice to occur and for the court to attempt to intimidate this counsel. Later, Love, who is a lawyer currently employed with the DA's office, argued that the ex parte hearing with Copeland was ethical, was just, and it was proper. So the government prosecutor, who works for Fannie, is perfectly fine. I don't know if she's sleeping with any other prosecutors or not. Maybe, I don't know. The other prosecutor still remained mute. Oh, maybe he was sleeping. Maybe they're sleeping together. I don't know. It's Fulton County. I have no idea. But so maybe she gave him the old eye, kind of like Fannie did with Nathan. He's like, oh crap. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions, and we declined to answer your questions, Judge. Why? Because we have our own ethical rules. A lawyer shall maintain confidence and professional relationships, and ethical rules state that the attorney-client privilege applies to judicial proceedings as well. And so I'm bound by the rules to not disclose information under the rules. Now, the court ignored those rules and continued to demand that Brian Steele reveal the source of the information, claiming that the way the undersigned counsel obtained that information was somehow unlawful, ridiculous, and basically accused undersigned counsel on the record of potentially acquiring the information through eavesdropping, like they hacked their iPhones or something. In response to the specious accusations this defense attorney Steele and the impermissible demands, undersigned counsel relied on my ethical rules and the Fifth Amendment. The court, though, is so biased against this counsel and my client that the court ignored all laws and pursued contempt penalties to try to intimidate this defense lawyer, and they did, and threatened him with jail. They said, we're gonna throw you in jail. And they did. The court issued a written order of contempt and incarceration for Brian Steele, the defense attorney, imposing the maximum sentence for 20 days. Now, the Supreme Court of Georgia has granted a writ of certiorari to address this appeal, and they've granted a supersedious bond, so he's now out of custody. But the judge ordered him into jail. Now, the court violated the law. This judge should have recused himself from presiding over this contempt proceeding. In these proceedings where the announcement of punishment is delayed and where the contumacious conduct was directed towards the judge or where the judge reacted to the conduct, the judge may give the attorney notice, but the attorney should be heard by another judge. So it should have gone to some other judge. This judge says, no, I've investigated myself. I'm doing a great job. Here, the court involved itself in these proceedings by joining the government's team and conducting the ex parte meeting that violated my client's rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the very heart of this issue. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rules were broken. The court should have recused. They should have allowed the contempt proceedings to be handled by someone else. And guess what? Did the prosecutors who were there in the interest of justice do anything or say anything about it? No. They work for Fannie. They were thinking about their next cruise. Prosecutors sat mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reported a violation of the law. We're in a post-law America, as we keep saying here. And promoted the court's wrongful conduct by asserting the ex parte meeting was proper. So then the court denied the defense request, saying that their due process rights were violated. They denied the right to notice and to be heard, to call hearings, and they just entered in contempt. There was no process at all. The court therefore then abused its authority by holding this defense attorney in contempt. Now, here's the motion to disqualify. The rules say we have to file that within 5 days. The Honorable Supreme Court has taught that a motion to recuse is filed timely when we do it like this, and so we've done it like this. Now, the record also reveals numerous instances at trial where the judge's behavior is biased against Mr. Williams. The record reveals other instances, too, where the trial court wrongly berated the attorneys in front of the jury. Now, after a number of these incidents, Mr. Steele, out of the jury's presence, moved for the judge's recusal. Says, Your Honor, enough of this. You can't keep doing this. And we seek a mistrial because you are showing a lack of objectivity. You had displayed bias against Mr. Williams and his attorney, Mr. Steele, and had assisted the prosecutors in making their case before the jury. Judges have an ethical duty to disqualify themselves when it becomes overly personal. And the Supreme Court is mindful about this. And prosecutors also must follow their ethics, but they don't either. And so while these several interests come together in this courtroom, we have them attached as Exhibit B. But joint affidavit, however, this exhibit, represents more than a mere friction between these lawyers and a judge. No, it's much more serious than this. The judge's conduct created the impression that he harbored ill will towards the lawyers and the defense. Higher courts need not decide whether this bias or impartiality actually existed, because judges are ethically bound to disqualify themselves when their impartiality might reasonably be questioned, including in instances where the judge's behavior could indicate he does have a bias. Now, as explained, the trial judge in this case, Glanville, participated in ex parte communications with the government, and he assisted the state to influence a witness to testify. You have to, it's almost like a settlement conference, which is what happens with defendants when you're trying to talk to them about taking a plea deal. You bring the judge in, and the judge puts a ton of pressure on them. You know, I could do this to you if you don't take this plea deal. You know, if you go to trial and lose, you could be facing the maximum standard on the law. So they bring that in, and the defense attorneys are at those meetings. So these actions certainly raised reasonable questions concerning the judge's partiality and bias. Why wouldn't the defendant be allowed to be there? Why? Because the trial, maybe because they shouldn't have been having that meeting. Maybe because the judge should not have been in there putting pressure on that witness. Because the trial judge's impartiality is reasonably questionable, it's an error to deny our request for a recusal. Now, our highest court has set forth 3 circumstances where recusal is necessary. Mr. Williams does not waive any of that. First, mere appearance of bias requires recusal. Here's 2 cases that share that one. And Georgia courts have also followed this demand for recusal many times. And also, due process similarly requires a recusal when the judge takes a role in the accusatory process, when you become a part of the case itself. Our court has explained that the Constitution prohibits a scenario where the judge orders witnesses to appear before him to gather facts about his own contempt. Yeah. This is because the judge-grand jury arrangement caused the judge to become part of the accusatory process, and so the judge must be recused. Here, Judge Glanville has ordered Copeland's lawyers and others to appear to give information on contempt. Same is against the law. And so importantly, a trial judge has a duty to recuse themselves. They have to do it sua sponte, on their own accord. And the phrase is broad. Recusal is objectively required when the judge is both the accuser and the adjudicator in a case. Here, the court met ex parte with the government and a sworn witness, and they never intended to reveal that meeting to the defense. Never. They tried to cover it up, or to anyone for that matter. So this witness was just going to, I guess, come out and start singing, and then he was going to let him out. The court has become part of the executive branch. They are assisting the government in prosecuting the defense. And moreover, the prosecutors have also abandoned and violated their ethical duties by engaging in this ex parte meeting and by sitting silent while the court attempted to get in there and lace into the defense. And they failed to reveal any Brady evidence as well, right? The government should have said, hey, this meeting happened, it was pretty bad, including the fact that the meeting occurred. It's total bedlam here. This is one of the most insane things that's happening. The judge was involved in it. The court and the prosecutors should not be working together, but they are, teaming up to gain an unlawful advantage over the defense. Mr. Williams' trial is constitutionally fractured. It's unfair. It lacks all constitutional, statutory, and ethical safeguards. The court is biased against the lawyer as well. No intellectually honest person could believe that coercing a witness to testify in a star chamber setting meets constitutional muster at all. Now, the court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, the judge, grand jury, biased, partial, potential sentencer, and thus he must be removed from the case. It is the duty of a judge to pass only on the legal sufficiency of the items before him. Neither the truth or of the allegations nor good faith may be questioned, but the test is whether there is bias on the part of the judge. Now, this court's conduct raises a strong finding that it has become, meaning you, judge, personally embroiled in this case. It's clear, even to a casual observer, that this court's involvement in the controversy requires this court to be disqualified. It's critical to our the integrity of our justice system that we have actual fair and impartial judges and jurors. And the rules say that you must mandate that you must be disqualified. And so this motion is now saying that Glanville should immediately cease to act upon all matters in this case, shall immediately determine the timeliness of these motions, and whether recusal should be warranted. The affidavit explains more, but the rules say that an objective observer cannot ignore this. He must be recused. A fair-minded and impartial person would hold a reasonable perception that he lacks impartiality. His conduct gives fair support to a charge of a bent of mind that may impede the impartiality of justice, saying this indictment must also be dismissed. A mistrial must be granted here. And the prosecution's continued misconduct shown below is in violation of our right to a fair trial. Judge Glanville and lawyers for the state, Prosecutor Love and Hilton, will be called as witnesses at trial for the jury to determine if this ex parte meeting mattered. And additionally, Mr. Williams demands all ex parte meetings to be disclosed right now in order to properly reveal the full extent of the violations of these laws and ethics. How many other meetings were there that we don't know about? Again, lawyers for the state, Love and Hilton, and Judge Glanville are necessary witnesses to determine whether this misconduct was goaded by these parties and this judge. This motion is just great. Based upon the above and the affidavit, if Glanville does not immediately recuse from any and all further matters on this case, you must send this motion to another judge to determine why Judge Glanville can continue to serve in this case. And further, a mistrial must be granted for these violations of these ethics. So we've got some exhibits here. This is the order for contempt and incarceration of Brian Steele. So the judge said, you're ordered, you go to jail now. He's going to be taken into custody for 20 days. Signed by Honorable Judge Glanville. And here's Exhibit B, joint affidavit of Brian Steele and Keith Adams. He says, okay, we're counsel for Jeffrey Williams here. We're over the age of 18. On Monday, Brian Steele asked for a transcript, and the court obstructed Mr. Williams and below affiance from having the exact image of what was said. That obstruction alone shows this court is biased. We wanted to know about your meeting. Was there an actual recording of anything discussed? They said no. There was absolutely no privilege in communications in the court's chambers. And there's certainly no attorney-client privilege over the stretch of the imagination that this court is trying to assert. And so this obstructionist conduct by this court shows bias, shows that this court is intrinsically intertwined in this case. There's no fair trial happening at all. Now, this court, by its word, used on the record when speaking in open court with the affiance, as well as the court's silence, as well as lawyer Love's statements in open court, clearly demonstrate that there was a meeting. So we picked it up from you. This court also silenced witnesses by properly issuing an order for contempt and making all witnesses in this case fear going to jail. And cross-examination of Ms. Copeland will include facts that occurred at this meeting, which puts the credibility of lawyer Love, lawyer Hilton, and this court in issue. And this court should never be the person who is in charge of the jury when the court's conduct is being questioned as well. Ms. Williams has been put into a trick box by the misconduct of lawyer Love, lawyer Hilton, and the court. And so this court must be recused. Now, more from this affidavit. Mr. Kenneth Copeland is a witness who had been called by the state. He was sworn in, and he invoked his Fifth Amendment. He was held in civil contempt. And unbeknownst to these attorneys, Mr. Williams or anyone else on the defense side, this court met in chambers with Mr. Copeland, with his lawyer Love, with lawyer Hilton, and a court reporter, and sheriff deputies were there as well, but no one told the defense. Deputies might have been instructed to turn off their body cameras. There's nothing privileged about this at all. The court and others met with Mr. Copeland for a lengthy period of time. The total ex parte, quote, meeting, which was an indoctrination threat session, lasted for more than 1 hour, maybe 2 hours, with the above-named people at the meeting. Mr. Copeland continued to make his assertion that he would not testify even in the face of being held in contempt. Even if you grant me immunity, I'm not talking. This court and lawyer for Fulton County, Fannie's office, ignored Copeland's decision and continued to declare Copeland that he would be held in custody until you testified. And if you refuse to testify, he would be held in custody not only until the trial is over, but until all 26 indicted people are all resolved. So basically forever. This court was a participant and was present during these threats to Copeland. This is witness intimidation. It's coercion through and through. The court has become a member of the prosecution team. They're assisting the government. This court, lawyers, Hilton, Love, they're all now witnesses to the case, and they will be called by Mr. Williams and others so that the jury can determine the demeanor and the credibility of what occurred at this little secret meeting. And please note that the witness list is hereby amended by this joint affidavit to include the prosecutors and everyone else. Now, the court also provided Mr. Copeland with a written copy of the statute of perjury. They said, oh, here's the crime that you're committing right now. This is no subtle gesture. This is one that helped the prosecution team obtain their mission to try to get Mr. Copeland to change his mind. This is the law you're violating. You don't want to violate this law. Look at the penalty. I can sentence you right here. The government lawyer Love made representations to this court in front of Mr. Copeland and his counsel and others, and she committed misconduct during his representation. Now, these are known misrepresentations, which Love continues to do to this court, which biases this court, and she continues to speak ill of counsel in front of the jurors. Now, the ex parte discussion violated Mr. Williams' constitutional rights. This court and the prosecutors spoke with a sworn witness and literally tried to get him to change his mind. These facts are assertions. On Monday, attorney Kayla Bumpus were escorted to the court's chambers with Copeland. So Copeland and Kayla, a client and attorney, go in. Those present for the substantive portion of this meeting were Judge Glanville, Mr. Copeland, the witness, attorney Bumpus, lawyers, 2 prosecutors, Love and Hilton, member of the court security staff, deputies, 2 investigators from the prosecutor's team, and a court reporter. So how many people is that? Judge, prosecutor, let's say 2 security people, 2 deputies, 2 investigators. So about 9 people. And then the other 2 attorneys are there, right? So the client and the attorney, so like 11 total. So it's the defense, it's the witness, the lawyer, and 9 people. So it's a show of force. They bring in the judge. He's in his robe. He's got this authority behind him. They bring in all these law enforcement officials, these government prosecutors. They're trying to scare the crap out of this dude. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Are you ready to testify, sir? He said, no, I'm invoking my 5th Amendment right. And they said, well, you don't want to do that. A conversation among the parties ensured that Mr. Copeland understood immunity. You understand what immunity means, right? And how he thought he may testify if he didn't invoke the 5th. Once he learned that he could be held indefinitely by the court if he refused to testify, not just for the 2 years as he thought initially, he decided that he would testify. Okay, so they bully him into flipping. He added that his testimony would then be a lie. He says, okay, fine. You want me to testify? I'll testify, but it's not going to be the truth. The meeting ended and the parties went into the courtroom. Now, the court never assured that this Brady evidence would go to the defense, and Brady evidence includes the fact that the meeting occurred in the first place. All right, are we back? I think we're back. All right, so I don't know what happens. My StreamYard just went out on me. All right, we're back. Sorry about that, my friends. We're back. All right, I don't know what happened. Where the heck were we? Okay, so this court, says Mr. Brian Steele, never assured that this Brady material, the exonerative material, made its way out. Instead, this court takes the position that no information about this meeting should have ever been revealed at all to no one outside the meeting. This shows this court has become a member of the government's team and that my client does not have a right to a fair trial. We have a right to present a defense. We have a right to cross-examine witnesses. We have a right to know about court intimidation of witnesses. And so this court must be recused. This court and the prosecution have violated his rights. We have to have a mistrial here. The state goaded Mr. Williams into moving for this mistrial of the court. So we had to bring this claim. And we also know on Monday afternoon, once we made this meeting and the fact that we knew about this meeting, once we made this known to the court refused to release the transcript of the meeting. And they held this lawyer in contempt. They ordered Mr. Williams' lawyer to serve the maximum time in custody, and they attempted to intimidate him from understanding and learning about the prosecution's wrongdoing. And so this court has become a material witness in this case, as have the prosecutors. The improper ex parte meeting with a sworn witness concerning the witness's willingness or non-willingness to testify is unforgivable. This is not an ex parte meeting that the court has had with the affiants ever. You've never met with us. On the very few occasions that we've ever had an ex parte hearing with this court, we announce in open court, you need to speak with the court ex parte. We need to speak with you. We tell everybody about it. We don't just have private meetings. Never was a witness involved in any of these ex parte meetings, because that's insane. Affiants demand, so the defense team, we demand to question this court. We demand to question you and the above lawyers for the DA's office as to how many ex parte meetings you've had. If we found out about this one, how many others were there? The substance of those meetings, who was present and the like. It's like a shadow prosecution happening. Nobody even knows. And the court's involved in it. Even if just one ex parte meeting occurred as it did, this mandates the court has forfeited its role as an impartial court, and you must recuse. The court has, on at least one occasion, been fed improper ex parte information about this case. The court met with the witness, spoke to a witness about their willingness to testify, and they didn't even notify us. The court has now placed the lawyer for Mr. Copeland and other unknown persons where they should come to court and testify. We should be able to answer questions about all those 9 people who were in that courtroom. The court has become the executive branch. They're conducting their investigation and they're pressuring this witness to comply. You falsely and wrongfully also accused Brian Steele of being unprofessional and unprepared in front of the jury. Neither claim was close to the truth. The prosecutor sat silent and just said, even knowing that the court has falsely accused Brian Steele of being unprofessional and unprepared, the court has refused to instruct the jury that that is not true. These are serious misstatements. He's following his ethical obligations, and the court is smearing him in the midst of it. Now, when Mr. Copeland took the witness stand on June 7th, he refused to testify and he was taken into custody. And this court knew, as did the government, that his refusal to testify in front of the jury, they knew he was going to do that, but the court did not reveal that to anyone or take any actions to stop it. In fact, his refusal to testify in front of the jury prejudiced our client. The jury should have never heard him exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit media from filming him, and the direction occurred before he took the witness stand. So the court is harming the defense by allowing this to go on this way. When Honorable David Botts brought to the court's attention that he had evidence that the prosecution knew Copeland was going to invoke, this court refused to have a hearing to determine if they knew. They just said that they had a problem with the attorney. This is backwards, okay, Judge? This court has shown bias against Mr. Williams, his lawyers, in favor of the government. And so this court must be removed. In sum, says Brian Steele and the defense, This court has obstructed justice by ordering any transcript of your secret ex parte meeting to not be produced to the affiants, to use or to particularize. So we can't even read it. Facts of the case were also discussed with this court at this impermissible ex parte meeting, and Brady evidence that would exonerate the defense was not even revealed to the defense. Mr. Williams, our client, has questions for this witness, this court, lawyers for the government, and others at this meeting. We want to know how it occurred, who discussed the fact that the secret meeting would occur, and the substance of this meeting, so the jury can decide whether the court and the state have colluded against Mr. Williams. I swear that the above is true and accurate from Brian Steele and Keith Adams. Man, wow, just insane. You think it can't get any worse in Fulton County, and they're having a shadow prosecution that's being conducted by the judge in chambers. I mean, say what you will about Judge McAfee. I don't know. Did he meet with the government witnesses and try to also help them prosecute the defense? It's lunacy. This judge is actively involved in violating the defendant's rights, and it will be amazing to see where this goes. Currently, we know the judge has, guess what? Denied the motion to recuse himself, and apparently is not going to pass it off to another judge, as Mr. Steele, man of Balzov, has asked happen.
Upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another
Just
judge.
bare
for it to be
accusations.
heard.
Yeah, nothing.
So I'm going to deny the motion at this point
you're
in time.
kidding.
I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made, doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up.
Take it up on appeal. So he says, I'm not going to even read it really and pass it off to another judge. I'm just going to say it's just legally insufficient. And so it doesn't even meet the bare minimum standard threshold for me to give it off to another judge for them to consider. So I'm just going to deny it on its face. You guys are going to go have to appeal it. We know what happens in Georgia. They got to get permission for an appeal. And the question on this will also be, can they appeal it interlocutory, right in the middle of this criminal trial? I'm sure they'll make that attempt. But we'll see if the courts will grant it. So it's total bedlam in Georgia, in Fulton County. This is Fannie's prosecutor's office, and this is an independent judge who's basically also working for Fannie. Don't know, there's a lot of weird things going on in Fulton County, a lot of weird relationships happening, and kind of an incestuous government over there. So we don't know what's going on, Fannie's relationship with him. I don't know. I don't want to make any implications here, but we do have questions because it is insane for a judge to have an ex parte witness come into his chambers where he can leverage his position as the judge with, I would say, 9 other people conservatively in the room to try to pressure this dude to try to rig a trial. It's not justice at all. It's post-law America. The law doesn't matter. It's about scoring political points. And there are a bunch of people here who are defendants in this criminal charade, having to be dragged through this process. In America, where we have a presumption of innocence is being dumped all over the place. So a wild case. We're going to keep our eye on it. Thugger Daily also has some good clips over there. Review. And they're on X. So we'll see what the man of balls of steel, Brian Steele, says, because he is coming in hard on that. And I also just want to say, I saw there was another clip of Mr. Steele when he was ordered into custody, just taking his jacket off, taking his tie off, no problem. He even asked if he could serve in the same facility as his client. Unbelievable. So we'll keep our eye on that one, my friends. Fulton County is bedlam. And as we cover all of this litigation and more, we'd love to have you join us here on our channel so that we don't miss you the next time we release something. Thank you for subscribing wherever it is you're watching us. Thanks for also inviting a friend or family member to come over here to our channel so that they can see what's inside these documents and what's happening in the various courtrooms around our country. We'll look forward to seeing you back here and them. And if you enjoyed this video, we've got a great video coming up next. We'll like to see you over there on that one next. All right, my friends, that is it for us on the day. We covered 3 good stories. This judge got destroyed in that demand for a recusal. We'll see what happens next there. Hunty Poo clearly exploited his relationship with his vice president daddy to avoid criminal charges. And now the whistleblowers are under attack. Congress is investigating that. And also Congress is fighting to reverse the J6 subpoenas. We have a new House resolution courtesy of Eric Burlison that is making its way through. Hopefully Republicans get their acts together and join in on that effort. But now, my friends, it's time to hear from you. Of course, we have some great donos, some great support. Thank you so much for becoming members, for inviting members, for sending in those donos. Couldn't do it without you. We also have our members only community at watchingthewatchers.locals.com, where we like to hang out after the show and debrief a bit. So come say hello to us over there, and we'll see you shortly. But let's see who sent in some amazing donos today. Our friend NY Renal MD says, I haven't heard one liberal lawyer with a rationale for a Trump post-verdict gag order. Who does it affect? The left has decided to throw off the veil and go full ideologue on anti-constitutional extremism. No doubt. We got this one. Tony Hay Munkets is bringing in 5 new membos. Look who's coming in. Burger Queen is here. We got Jackie G. Freed is coming in. We also have Blocks in the house and James B. Gifted membos, courtesy of Tony Hay Munkets. Thank you, Tony, for the new membos. Lenny M. What's up? Says, please smash the like button. Please like this video. Please share and subscribe and share this on all social media platforms. And God bless you all for doing that. Thank you, Lenny. And thanks for the reminder. B-Man in the house says, my question is, can they legally keep the gag order on President Trump? Also, not a peep out of the jurors. Very strange. Yeah, it is pretty strange, right? No jurors were calling into CNN. Like the Hunter Biden jurors, that guy was calling all over the place. But yeah, they can. They're doing it right now. The New York Court of Appeals just denied Trump's request to reverse the gag. There's no real good justification for it, but yeah, they're doing it legally right now. And we'll see what other release conditions, what other sentencing conditions they put on Trump. What's up, Poppy? Welcome aboard. Thanks for becoming a new supporter on the YouTubes. Philip C. says, in this episode of the Tales of the K-Fob Insurrection, yeah, the made-up insurrection that the feds and Pelosi organized. Hey, what's up? Chubby says, bad news for me. Oh, no. I won't be making it out to Vegas for the meetup. The refrigerator decided it identifies as a huge waste of space, so unfortunately I have to use the money I budgeted for a trip on a replacement appliance. Oh, man. Hopefully there'll be another meetup in the future that I can make it to. Hope everyone has a great time out there. We're going to miss you, Chubby. Sorry to hear that, man. So we will miss you. Refrigerators are pretty important. You definitely need a refrigerator to keep things cold so you can eat and survive. But we'll miss you. And you're going to have a great new refrigerator. It's going to be awesome. And we'll have another meetup for sure. Sorry, we'll miss you. But we'll catch you on the next one. Hey, what's up? Brittany Z. Rob, you said the website had the calendar. I heard wall calendar, with pictures. I was like, a Watching the Watchers calendar? Of who? Yeah, we could do one of those, calendar with different photos on there. Like, what would we put on there? Well, I don't know. I don't know what would be on there. It's a good question, Brittany. Who knows? But no, we actually have a calendar on the website that has the show schedule on there. We got this one from Just Rhonda. Bringing in new members. What's up, Just Rhonda? Bringing in Greg E. Sweet Tat is coming in. We've got John O. Seraph C. in the house, and Tripos are gifted membos, courtesy of Just Rhonda, who's a membo, bringing in 5 new membos. We got Daisy Girl Williams, membo for 12 months, 1-year anniversary. And Daisy Girl, what a nice comment. Adam5209 is in the chat, asking for prayers about a job loss. Adam, we will send some good love, energy your way, and we'll also remind ourselves that these are often feels like losses, but also great opportunities for us to recalibrate, reassess, re-envision our futures, and hopefully build something much better. So it's an opportunity for growth. I know it doesn't feel that way right now, but I'm hopeful that with some good love and some good energy sent your way and some prayers, the universe will align so that your unique ability will align with the right opportunity, and boom, it's going to be a match made in heaven. It's going to happen soon. Thank you, Daisy Girl, for sending that in, and thanks for being a membo. CF Rob says, but Hunty is a private citizen and has no connection to Joe Biden, says Karine. Oh, yeah, you're right. So you're right. You're right. So Joe's innocent. Hunter's innocent. I apologize for wasting everybody's time. I know you're just kidding, CF Rob. I'm also being sarcastic. What's up, Granny Joe? Membo for 4 months. Hey, thanks for saying that, Granny. Membo for 4 months, almost halfway to a baby. Says, always grateful for all the hard work you do. Thank you. Thank you, Granny. I appreciate you being a membo and being here. We couldn't do it without you. So I'm grateful for our friendship here together. Dolphin Fan is the man. Bringing in 5 new membos. Paul E. just came back in. No, you won't get your CDs back. Stop asking. You've been asking since 1998. They're my CDs now, is also joining us. Dr. Mimo came in. Wade S. is here. And Mitchell and gifted membos, courtesy of Dolphin Fan, is the man in the house. What's up, Lenny Malley? Gifted a new membo. No, a membo for 14 months, rather. Love you all, and God bless you all, from Lenny Malley. We love you back, Lenny. Thanks for being a membo for 14 full months. That's almost 2 babies in the house. What's up, Mrs. Hayes? 11 months as a membo. What's up? Says, kindly asking for prayers and good vibes. Thanks, Rob. My friends, send some good loving energy, some good vibes, and some good prayers to Mrs. Hayes, the Mrs. Hayes household. 11 months as a member, 1 month for that full anniversary. Sending your way now, Mrs. Hayes. Good to see you, Mrs. Hayes. Thanks for that. Ray Ronk says, this happens too often. Last year, a sheriff threatened me if I did not disclose who had come to me for counseling and help with unjust persecution. Wow. Yeah, that doesn't sound good, Ray. And I know a little bit about the work you do, Ray. Very interesting. Yeah, I do know about the work that Ray does. That's so okay. So the sheriffs are coming to violate your counseling, right? Your sort of doctor relationship privilege. Very interesting, Ray. Sorry to hear that. Brian R, what's up? Says, can Thug Glanville be removed and disbarred? Sounds like he should be. So hopefully somebody in Georgia does something about it. Sounds like they're going to appeal that, but I think they might need Glanville to give them permission to appeal it. So we'll see what happens next, but we'll wait for his order to come out. But it sounds like he should face some serious repercussions for what we just witnessed here. 13 months as a membo. Thanks for being a membo, Brian, for the full 13 months, man. That's a year plus 1. Good to see you. Hey, it's the Munkets is bringing in more membos. Crypto Beauty is coming in. We got Knowledge is here. Prince Vibes, Tony R, and You Did What? All coming in, courtesy of Tony Hay Munkets in the house. We got this one from Tyler. Says, my understanding is that Copeland was going to take the 5th because he would incriminate himself federally and only has immunity from the state. Yeah, JC says he did take the 5th Friday before last, Monday morning, but the judge and the prosecution and Woody's temporary lawyer had a secret meeting where they extorted Woody to tell, and his attorney thought it was bad. Yeah, good details on that. And yeah, we're coming into this case a little fresh, so we're still picking up the pieces with you. Rob says, Rob, we thought the FBI got you. I know, my screen just was like, it just refreshed. I don't think it's ever done that before. Wasn't the feds. Ugh, I know. Hey, travel agent Amy says, hey, I resemble that next cruise comment, but I'm not anything like a fanny. I have a fanny though. Well, we all do. Yeah, most of us do. Some people don't actually. You've seen them. You're like, where is that person's fanny at? I don't know where it went. But Fannie definitely has one. And she's the biggest Fannie in Georgia. And that's not a fat joke, okay? She made it. She made that up. She made that Fannie joke up. Travel agent Amy has the cruise knowledge. If you're looking for a travel agent Amy will help you with that. And she resembles that comment. I love that. It's not I resent the comment. I resemble that comment. You do, because you're a travel agent. Good to see you, Amy. Thanks for being here. We got Londo says, thought we were going to have to dial up Rob on the ham radio for a second. But wait, I don't have my ham license. I know. Tony Hay Munkets, what's up? The long and the short of it, got gifted a membo from Tony Hay. Great to see you, Tony Hay. We got Mustafa in the house. Says, the first debate ends on a cliffhanger. The second debate after sentencing. Judge orders house arrest. Trump misses it. Convicted felon narrative snowballs. So, yeah, house arrest, but then Trump violates house arrest. So then the judge orders physical incarceration, and Trump is now this felon who's campaigning all across America. Good to see you, Mustafa. We'll see where it goes. Sentencing's coming up. Felix says, Biden, Fulton, New York lawfare is fascism. Yeah, Dan Goldman. And you're a New York representative. What's up, Keith Newport? Welcome aboard, Keith. Thanks for being a membo. We'll see you tomorrow morning for our membos only morning stream. It's going to be a beautiful Wednesday stream. I can feel it. Zulu, what's up, Zulu? Thanks for modding the fort down for us, bringing in new membos. Guess who's coming in? Courtesy of Zulu. JA's in the house. Patrick W, welcome. Anonymous Jeff, Saran. We got Ken D, Kelly R, Golden Gaming, what's up? Dennis H, Economath is here. Andy C, Aging Cynic, and True Seeker Human all shouting out. Zulu, thanks for bringing in 10 new membos. Cowboy Rob says, if the hearing is over, how would the judge have jurisdiction over what a defendant says? Well, it's technically not over, so Trump still has sentencing. And I get, the court's justification for this was administration of justice. The case is still open. I think the judge can really retain jurisdiction while Trump is serving his sentence, clearly. So if they put him on probation, the court will have jurisdiction over that. If probation has a problem with him, then they'll come back to the court, and the court can say, you violate your probation, essentially. It depends on what the sentence is. I know he's still got jurisdiction for sentencing, but damn, yeah, I know. And we'll see what he does after the sentence. Felix is here, says the J6 committee and DC are a den of fascist vipers. Also true. Mighty Family of God joined us as a new supporter. Welcome aboard, Mighty Family of God. Great to have you in our members only community. Hey, what's up, Mighty Family of God? Says new member. Thank you for all you do and God bless. What a great comment. Londo, promise to Rob only one DC originated conspiracy per day. Sorry it was confusing. Apparently an inside the Beltway thing. I think I'm hearing what you're saying, Londo. Thanks for that. And Mighty Family of God in the house, new member. God bless you back, Mighty Family of God. Thanks for that. Glad to have you as a membo. We'll see you in the morning on the membos only streams. Will be great to have you there. And so, my friends, thank you so much for all those incredible donos that have come in. We appreciate your support. Could not do it without you. We've got some friends on X that we'll say hello to before we go on over to locals to wrap up and say what's up to our locals friends. Let's see. This is this link here. Who's on X joining us in the house? Hey, Fred Pedamonte and Rando says, where'd you go? Oh, you're back. What's up? Fred says, also, both prosecutors told Copeland that they wouldn't prosecute him if he lied on the stand, which is illegal. Crazy. What's up? We got this one from our friend George. George says, shout out to all the Watching the Watchers crew. Says, keep it up. Man, look at these very handsome animals right here. Kitty and puppy in the house. What's up, George? Beautiful animals, and they look like they're getting along. Cats and dogs snuggling together. What is this, madness? Gramps House says, about time someone has tried to do something. The GOP Congress doesn't understand what power is. No, they don't. They just like to go along to get along. They like to hang out with the Democrats at their cocktail parties. So, all right, my friends, that is what we had over on the X platform. Thanks for following us over there and saying what's up on X, following other watchers out there. We are going to go on over to watchingthewatchers.locals.com right now for our members only after party If you are a member on Locals, that's where we'll see you. We have our website, robertgovea.com. We have the PDFs that we talked through today will be posted up over there in our show reports section. We have a daily newsletter, a merch store, and a show calendar there. And we'd love to see you come join us in Las Vegas. Tickets are available at watcherlodge.com. And you can grab them. We're going to have a nice lunch. We're going to have a hang session. We're going to meet up, connect, and do some fun activities. It's going to be great. So come check it out, watcherlodge.com. And come to Vegas. What else are you doing? Come to Vegas. It's going to be fun. All right. That, my friends, is it for us on the day. Before we wrap it up, I want to say thank you to our mods and our meme smiths who keep this place nice and tidy and orderly in the house. Our friends K Bean in the house. We got Just Cause, Playing Hooky, Ronnie Cole, our friend Zach Nichols, Janek, Dog Digger, Economy Pilot, Donut Mind Me, Carrie B, Zulu's in the house, keeping things nice and orderly. Shout out to our meme smith, Sleepy Dog Lee, Nathan, N810, Geegum Geegum's here, Glocky McLock, and Elliot, our Doc Master. My friends, that is it for us on the day. Now, of course, we are going over to Locals for our members only after party. We'd love to see you there. But if we don't, we are going to be back here tomorrow. It's going to be a beautiful Wednesday. We're going to have business to attend to. And in order to do that, we're going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.